Welcome, Dana Sparks, broker of Maximum One Greater Atlanta Realtors. And this week's contract tip has to do with your real estate contracts and a survey. So the 2017 GAR, Georgia Association of Realtors contracts, removed the paragraph regarding a survey being attached to the contract. So prior to the 2017 printing, the GAR contract stated a survey is or is not attached. And then the legalese per that provision stated if the buyer purchases a new survey and it is materially different from the survey that is attached to the contract, the buyer has the right to terminate the contract under no penalty. And that right went through day of closing. So GAR took that out of the contract for 2017. They took that buyer contingency out because the buyer basically had a contingency through day of closing where they could terminate. So what do? Well, first of all, is it a good idea for a buyer to get a survey of the property they are purchasing? Well, yes, of course they should. Do buyers often get surveys? That's another question. So basically, in the GAR contract now, since they did remove that specific buyer contingency regarding the survey, they do have under paragraph, this is the GAR, Georgia Association of Realtors Purchase and Sale Agreement, under paragraph B1B, under the purchase and sale title paragraph, under examination, it does say that buyer may examine title and obtain a survey of the property and furnish seller with a written statement of title objections at or prior to the closing. If the seller fails or is unable to satisfy valid title objections at or prior to the closing, or any unilateral extension thereof which would prevent the seller from conveying good and marketable title to the property, then buyer, among its other remedies, may terminate the agreement without penalty upon written notice to the seller. Good and marketable title, as used herein, shall mean title in which the title company licensed to do business in Georgia will insure at its regular rates, subject only to the standard exceptions. So that's all it basically says, is the buyer is entitled to get a survey. Now also, the title insurance that is quoted per the contracts per TRID, per the Consumer Financial and Protection Bureau's new laws, the Truth in Lending RESPA integrated disclosure laws, basically says that they have to be quoted the price for an enhanced title insurance policy. So basically, an enhanced title insurance policy typically has full coverage, but there may be a pretty hefty deductible if there are issues having to do with a survey. For example, easements, encroachments, improvements, building lines, so forth and so on. Now, if a buyer does get a new survey at the time of purchase and sale, and that goes in with the title insurance, then they should have full coverage for that without any deduction. Y'all, please check with the closing attorney, closing the transaction, doing the title search, and the closing attorney based on the company that is issuing the title insurance for that property. So that's in general, but let's go back to the contract. So again, the GAR contract, that's what it says in the purchase and sale agreement in and of itself. But GAR has a special stipulation that you should pay attention to. And the special stipulation says, for the additional consideration of $10 and other good and valuable consideration paid by buyer to the seller, the receipt and sufficiency of which is hereby acknowledged, meaning that $10 never actually changes hands, it's just the consideration for this provision. Buyer shall have the right and responsibility to procure a survey buyer shall have the right and responsibility to procure a survey of the property to determine if the property is acceptable to the buyer and notify the seller no later than blank, you fill in a date, if the buyer elects to terminate under this provision. So that's a special stipulation that you may use in the GAR contract for the buyer getting a new survey. Now let's switch a little bit to the RE forms contract. In the RE forms contract, under the standard terms, which is a part of the contract. And again, Maximum One's policy is that you print out the standard terms and reference them as an exhibit. If you're not with Maximum One, you should print them out and reference them as an exhibit for your protection as well as for the buyer's information. Basically, it says under paragraph 1, under property description, it clearly states that the seller shall convey to buyer good and marketable title to the property by limited warranty deed, free and clear of all mortgages and liens, except the property shall be subject to taxes not yet due and payable, and all other encumbrances, zoning ordinances, easements, and restrictions of record as of the acceptance date of the contract. Good and marketable title is used in this contract, same thing as with the GAR contract. Shall mean title in which the title insurance company licensed to do business in Georgia will insure at its regular rates, subject only to standard exceptions. So the RE forms contracts also have a special stipulation specifically aimed at a survey contingency. And in the RE form special stipulation, it states, it is understood and agreed that this contract is contingent upon buyer on or before blank date, you fill in the date, securing a survey from a licensed Georgia surveyor of buyer's choice, which confirms that the boundaries and overall size of the property are reasonably consistent with the boundaries and size of the property represented by the seller. In the event any such survey is not reasonably consistent with seller's representations, buyers shall have the right to either 1, terminate this contract by delivering notice to the seller no later than midnight of the day that is blank number of days after the date set forth above, in which case the earnest money shall be refunded to buyer, or 2, waive buyer's objections, in which case this contract shall remain in full force and effect. So, bottom line, should a buyer get a survey of a property that they are purchasing? My opinion, absolutely. They should know what it is, what the boundaries are, what the easements are, what the improvements are, what possible encumbrances are, so forth and so on. Because you could get a title policy that references an easement, for example, utility easement, but it does not indicate the location of that easement, and so forth and so on. So, should a buyer get a survey? Yes. Relative to the contracts, is it contingent upon that? No. But agents, y'all need to take a look. You need to have this conversation with your buyers, and you need to take a look at these special stipulations in both the GAR and the RE contracts if the buyer is going to get a survey and if the buyer wants to make their purchase of the sale contingent upon that survey. How does that interact with title insurance? Again, with the enhanced title insurance policy, there may be some coverage, but there may be a deductible if it is a survey issue. And as I just mentioned, the title search could show something to the effect of there is a utility line easement, but not show the location of that. Would that be important for a buyer wanting to put up a fence on their property line? Probably. So have a conversation with your buyers about having surveys, take a look at these special stipulations, and have a really good conversation with the closing attorney that will be performing the title search regarding what that specific title insurance company does cover in an enhanced policy regarding any survey issues. Thank you so much for watching. Again, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.